Data protection requirements for your company. In 2019, National Information Technology Development Agency (NITDA) imposed a sanction of 10 million naira on an online lending platform called Soko for data privacy invasion and violation of customer rights. That fine could have been avoided if the company had complied with the provisions of the Data Protection Act. So, if you have a tech company or you have any company at all and you want to avoid unnecessary legal sanctions against your company, watch this video to the end because I will be sharing the data protection compliance requirements for your company in line with the Nigerian Data Protection Act 2023. Are you ready? Let's go. My name is Olayiwola. I'm a business lawyer and a digital law practice consultant. I legally fortify businesses against lawsuits and I teach lawyers how to make money online with their legal skills. Welcome to my YouTube channel where we talk about everything law and tech. So, let's dive in. We know that tech companies thrive on data. Due to the nature of tech businesses, most tech companies collect user data such as names, addresses, phone numbers, email addresses, and a lot of other things. This makes it important to protect user data against unlawful access to avoid data breach. You know, people's data can be used to commit crime or even to defraud them. Data breach is a serious offense that attracts fines from the Nigerian Data Protection Agency. It can also affect the reputation of your company. I will give you an example. In 2019, the National Information Technology Development Agency (NITDA) imposed a sanction of 10 million naira on an online lending platform called Soko for data privacy invasion and violation of customer rights. It affected the reputation of this company so badly that Google search engine took down their business listing. You see, getting fined for data breach can also affect your company's reputation. It can make it difficult for you to make sales or even get investors. I mean, who would want to invest or do business with a company with a bad reputation? So pay attention to the data protection requirements for your company. The first data compliance requirement is to collect data with consent. It is a crime to buy data or steal people's data. On your website, there must be a place where people can check a box to agree and willingly give you their data. You must tell them why you are collecting their data, what it will be used for, and how it will be stored. You must also tell them their right to withdraw their data at any time. 2. Lawful processing. You must inform them about how their data will be processed and be sure they agree to your data processing style. 3. Data security. As a startup, you must ensure the security of the data in your possession by protecting your system from hackers, setting up firewalls, employing the use of encryption technologies, organization policy for handling personal data, and other methods of system protection. 4. Data must not be retained for longer than it is necessary to fulfill the legitimate purpose of which you collected that data. So the data must not be in your system after you have done what you wanted to use it to do. 5. Data must be accurate and complete. It must not be misleading. You must be sure to collect the right data. 6. Third-party data processing contracts must always be in place. So if you have to employ a third party to help you carry out jobs that require you to share the data of persons you have collected, you must have a written contract in line with the data protection regulations. 7. where the processing of personal data may result in high risk to the rights and freedom of the data subject. You are expected to carry out a data privacy impact assessment to identify the possible areas where data breaches may occur, where it may likely occur upon the commencement of a project. And you must also develop a strategy for addressing such risks. Number 8, if you engage in the processing of personal data of over 1,000 Nigerians, you are mandated to conduct a detailed annual audit of your data processing activities. This audit is to be conducted by a licensed data protection compliance organization, DPCO. Failure to comply will result in the payment of fine of up to 10 million naira or 2% of your annual turnover, whichever is greater. Number 9, you must appoint a data protection officer who is knowledgeable in data protection law, who will advise you on the data protection compliance for your company. The data protection officer will monitor the compliance of your company, and it will also serve as a contact point with the commission. Number 10, you must have a data privacy notice on your website. The notice must inform your data subject how you collect data, why you collect data, what you use the data for, and how you process the data. 11, you must have a data security standard and organization policy for handling personal data. This policy must be circulated amongst your staff and everybody handling personal data, including third parties that are working with you. They must have the data protection policy for your company. Number 12, your company must also have a robust response plan in place to effectively manage and respond to breaches. You must ensure the protection of individuals' personal data. So if there is a breach in your company, there must be a format for you to respond to it. 13, you must communicate with the commission if there is a breach in your company data within 72 hours of you being aware of the breach. So if there's a data leak, you must tell the commission within 72 hours. Number 14, where the data breach will affect or potentially affect a data subject, that data subject must be notified immediately. So if the data breach will affect the people whose data you have collected, you must notify those people immediately. The notification should also include advice on possible ways of mitigating the potential adverse effect of the breach on the data subject. Those are the people who gave you their data. Then number 15, cross-border transfer of personal data is normally not acceptable. But if you have to transfer data to another country, it must only be transferred under special circumstances with the consent of the data subject. So you must tell the people who owns the data, and you must show that there is adequate data protection in the recipient country, that country where you are transferring that data to. You must show that there is adequate data protection policy with that country and that company who you are sharing the data with. Number 16, you are to register your company with the commission. So you are to register your company with NITDA. If you fail to comply with the provisions of the Data Protection Act, as I have stated in this video, your company will be liable for a fine just the same way they fined Soko Loan to the tune of 10 million naira, and you even risk imprisonment. The company executive risk imprisonment or both. So you can get fined and you can also get imprisoned. So after watching this video, what I expect you to do if you own a company or you own a tech startup is for you to contact a lawyer, a data privacy lawyer, for you to know what exactly you have to do, your data privacy requirements and obligations, so that you will not be incurring unnecessary government sanctions upon your business or your company, and then you will not also lose company reputation. If you have learned from this video, like this video, share this video, and subscribe to my YouTube channel so that a lot of other business owners like you can also watch the videos on the channel and benefit from the videos. You can also turn on notifications so that you will get notified every time I upload a new video. Bye for now.